privacy, the autonomy of choice, and thus the right to enter into relations of family, the right not to be treated differently. Lord Narasimha doesn't have that?
I'll drop it to you.
It's called
written
submissions on behalf of the Attorney General for India.
I have a hard copy. I thought.
We are a little allergic to hard copies.
That's not the idea.
It was sent.
Yes, yes. Yes, yes.
When did it send? This was sent about 3 days ago. Choice under the right to enter relations of family, the right not to be treated differently, accompanied by all consequential restraints against state and its authorities, as not to deprive them of all rights and benefits flowing from the status of marriage. And consequently, a statutory impediment to the realization of the above status, enacted in Section 4 of the Special Marriage Act, be declared to be either unconstitutional or to be so read as secured to them without any qualification. The same status of marriage is available to heterosexuals. Before I read further, a little digression. The other day, you lost referring to the 242 Law Commission report.
Yes.
About,
Where you are a member,
That's right.
attorney.
Even in that report, where I was a member in the commission, and I happened to write the concept note for that report. Even in that report, while writing that report, we had probably thought about this issue. And there is some statement why the definition of marriage may not be so enlarged as to include certain issues. The trigger point behind that report was about the Kap panchayats and impediments in freedom of marriage as such. If you also notice that there is a statement about that, I'll come to it a little later. So para 2, it's canvassed that with a requisite redrafting of certain provisions of the Special Marriage Act, that's by a combination of declaration as to lack of attention to or non-inclusion of relationship other than the heterosexual unions vitiating the Special Marriage Act 1954, and declaring on the importance of securing to non-heterosexual unions a wide range of rights, claims, and interests attached to and consequent upon a marriage to follow, the needful will be done to bring about non-discrimination. The submission proceeds on the footing that with a minimal exercise of redrafting of the Special Marriage Act, by a process of construction and interpretation, all other measures can follow, either by necessary statutory intervention or by conformity by state and instrumentalities, with a declaration to be given by the Honorable Court. The following submissions are made in response to the above. The challenge to the Special Marriage Act is misconceived. The said law is a species of the general laws relating to marriages applicable to different faiths, religions, or sections of the community. All these legislations or instruments relating to marriage having the force of law carry one common feature, namely the conception of marriage as a union of heterosexuals, and with procreation is the essential feature of such union as a family, among other aspects and dimensions important to such a union. Marriage as a union of heterosexuals has always been rooted in the family as a social unit. Heterosexual union is a feature common in many species. The Special Marriage Act is not a law based on a special and distinct conception of marriage outside the general law of marriage. It is not a law creating an institution of marriage. The Special Marriage Act is only a law in relation to the institution of marriage. It's a law conceived in aid of such a class of persons who may be otherwise disabled or obstructed in accessing the institution of marriage. It is thus a non-discriminatory legislation, not being in violation of either Articles 14 or 15 of the Constitution. The sole object of the Special Marriage Act being facilitating and enabling certain class of persons desirous of accessing the institution of marriage. It intends to provide equal protection of the laws within the scope of Article 14 of the Constitution. Being so designed, it has no discriminatory content. As stated above, the Special Marriage Act is an enabling and facilitating legislation based on the common conception of marriage as a union of heterosexual, the underlying premise in all laws relating to marriage. Marriage as the union of heterosexuals being the universal conception of marriage as such, the question of keeping in mind claims of other unions as marriage and to accord them the same treatment did not arise while enacting the Special Marriage Act. The debates in Parliament relating to the Special Marriage Act bear testimony to the above. As such, the Special Marriage Act cannot be seen in isolation or singled out for an attack on discrimination or unequal treatment. The Special Marriage Act 1954, therefore, cannot also be found fault with on the ground of under-inclusion. The test of under-inclusion or over-inclusion enters the debate only when all classes or categories of persons or entities relevant for a statutory purpose are conceived and identified, followed by inclusions or exclusions. The conception of marriage premise on a heterosexual union, coupled with procreation as an essential feature, stands as an exclusive conception. At the time Special Marriage Act was debated and conceived, an alternate conception of marriage of union of persons other than heterosexual union did not enter the picture, not because of design, or because of intent. It cannot therefore be stated the omission of considering or not treating the union of non-heterosexual persons on par with the heterosexual union in the Special Marriage Act is an omission to be constitutionally faulted and an omission amounting to discrimination. There was thus no under-inclusion, as if an alternate conception of marriage was perceivable but disregarded. From saying that the conception of marriage must now receive expansive connotations to accommodate all unions of persons as a family without reference to or conditioned by sexual orientations or factors, it does not follow that the prevalent conception of marriage as the union of heterosexuals was always narrow and weak. The question of updating a law can arise when the law in due course fails to realize its avowed purpose, not when an alien purpose is sought to be brought into the scope of the law. Based on the conception of marriage, common to all domestic laws and instruments of law relating to marriage, the Special Marriage Act has enacted a special scheme of provisions, particularly sections 19 to 21 of the Act, that the provisions of the Act have an intrinsic internal cohesion and no part of it can be severed. Similarly, by reason of law being premised on the union of heterosexual couples, all corresponding provisions relating to marriage, divorce and separation, etc., have also been enacted. It is submitted that the Special Marriage Act is not an impediment in the way of the absence of social recognition and the acknowledgement of a non-heterosexual union. The question is not one of the relevance and importance of social and legal recognition of the autonomy and choice of persons to live in chosen relationships triggered by their sexual orientation or sexual features. The question, however, is whether engagement of the court on the project of securing social and legal sanction for such choice and relationship was to come only by recourse to discourse on Special Marriage Act or to be confined only to that. The question of altering the text of the statute by any process of interpretation can arise when, in the absence of such an alteration, the stated purpose of the law may not be effectively realized. In other circumstances, such an alteration or supplying meaning to the text may arise when the statute is thought to be read on as to save the law from being invalid. On the statements about the Special Marriage Act made above, it is submitted the law is not expressly or otherwise unconstitutional. A law not being unconstitutional, the question of reading down or reading in may not arise. The importance and desirability of securing to all non-heterosexual persons social recognition and enjoyment of rights and responsibilities, whether available to persons in marriages sanctioned now by law, while deserving of great attention. Such a project of securing equality of status and treatment may not be best achieved by the judicial act of erasing out the fundamental features attached to the conception of marriage under the Special Marriage Act, nor it can be realized by the mere substitution of a few words and phrases in the Special Marriage Act 1954. Such an exercise, howsoever desirable, and without further full-length